Hey y'all, it's all Rosie here. What's blooming? Now, if you're busy like most and don't have time to tune into this YSL Young Thug Trial every day, don't worry, I've got you covered with a breakdown of what's going on. So buckle up because we're about to peel back these petals on the first nearly 100 days of this roller coaster courtroom ride. Now, if you have been following along with the live stream courtroom coverage, then you'll know that this trial has been nothing short of a blockbuster movie. From shocking revelations to heated debates, we've seen it all in the past over 90-something courtroom days.
Madam, I do find you in contempt, but here's what I'm going to do. Contempt is punishable usually by a fine of $1,000 and or 20 days in jail. I am not going to fine you. I'm going to, well, first, Madam, did you attend college?
Yes.
You have a 4-year degree?
Yes, yes.
Say again?
Yes.
All right. What I then want to do is, in order for you to satisfy your contempt, I'm going to commute the 20 days and require you to write a 30-page paper on the importance of jury service. Here's the criteria. You'll have to do APA style. You're going to have to use at least 10 primary sources, 10 secondary sources. You'll talk in a minimum, and I'll write this in the order. You'll have an order. You'll have it before you leave here today. You're going to write in a minimum the history of jury service, who could not serve on a jury, because that's very important, because years ago.
You know the case right now, Your Honor.
Sir, I'd be real careful about what you're pleading at this point in time and what you're stating to the court.
I'm so high right now, y'all. I'm about to go to sleep on y'all ass.
Now, let's start here. What is this trial about? Well, this is a conspiracy case in which the state has brought charges against Jeffrey Williams, also known as Young Thug, as well as a whole list of others connected to the YSL rap label, also interchangeably referred to as YSL Gang. Now, the state of Georgia alleges under the direction of Young Thug, these individuals conspired to a number of crimes to include drug trafficking, unaliving, and other heinous crimes, hiding behind the YSL record label in order to further the YSL street gang. The indictment included 28 defendants and 56 counts, and this case is being tried by acts, and currently there are 6 co-defendants up on these particular acts, and right now the prosecution is calling witnesses to testify regarding these particular acts. Now, what's an act? An act itself is not necessarily a crime. For example, it's alleged that Young Thug rented a car for Woody that was ultimately used to commit a crime. The act itself of renting a car is not illegal. However, homicide is.
Do you remember telling Detective Gaither that when Kel got on the phone, that Thug said the beef ain't over with until you pay for my window? You shot my window.
Yes.
Now let's quickly recap this first nearly 100 courtroom days. This has been an extremely long trial, and it's hard to imagine jurors are still focused and following along. And rumor has it, they appear to have a look of being checked out. Now remember, this trial started in late 2022, and it took a whopping 10 months just for jury selection. And it's been said that these juries get paid roughly $25 a day with no travel or lunch stipend. And there are questions if they're even getting paid all of their money that they're owed. So now the makeup of the jurors in Fulton County deciding the YSL case are 85% Black, 90% are women, only one Caucasian woman because the other one moved out of the area, so she's no longer there. There are 4 Black men, 2 white men, and 5 Black women. The ages are alleged to be in the range of about 23 years old to approximately 62. We are now into nearly 100 days of deliberations with dozens of witnesses still yet to take the stand. And speaking of witnesses on stand, currently Kenneth Copeland, aka Woody, is a witness for the prosecution. He has had a quite entertaining, at least for the viewer, presentation on the stand. Now, with viral moments across various media platforms, it has brought more attention to this trial, and it's even alleged that jurors have been observed laughing at Woody's comical testimony.
What's your pleasure?
Say what?
I said, what's your pleasure, sir? Do you wish to give testimony? I know you don't want to give testimony in this case, but you've been given immunity in this particular circumstance, use immunity. So, are you going to testify?
Yeah.
Okay.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am?
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take me into custody.
And when you were younger, did you go to school?
Yes.
Where did you attend school?
I don't know. I went to a lot of different schools.
Okay, where are all the schools you went to?
I don't recall all of them.
Oh, just tell me some of them.
I only know one, Slater
Later. Is that elementary school or middle school?
Elementary.
Why you don't remember what middle school you went to? Did you go to middle school?
I think I did.
How long did you go to? Did you finish middle school?
Relevance.
Overruled.
Yeah, I think.
Okay. Did you go to high school at all?
Yeah.
All right.
Young Thug's attorney Brian Steele's performance and advocacy for his client has also brought much attention to this trial, as news of his ordered contempt and jail by Judge Glanville made it all the way to the Supreme Court.
I was told, based on information and belief, that when we arrived at 8:30, 9 o'clock today, he did not come to your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers of I'm a court reporter at times, on recorded times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. Well, I'm going forward. What I was told was that Mr. Copeland said, and you haven't answered my question yet. How did you? That question. You're not? No, I will not answer that question. Why will you not answer that question? Because I want to make sure that what I say is accurate, and I'm not trying to... No. I'm asking you, how did you get this information? I'm not telling the court. What I'm saying is based on information. Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems. We can have it. I have problems right now. Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with the party. I mean, a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland. Tell me how you got the information. Listen, tell me how you got the information, then we can go ahead and go forward. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court. It concerns me that you have proprietary information. Why is it information that you should not be having that was ex parte? Why? With a party. Why? State of Georgia. How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but what I did. Mr. Steele, I still want to know, how did you come upon this information? Who told you? What I want to know is, why wasn't I there? Why, sir, I'm going to hold you in contempt if you don't tell me who this. Tell me who this information is. I don't want to be held in contempt. Well, then answer that question. That's attorney-client privilege information. I have not attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out. I tell you what, I'm going to give you 5 minutes. If you don't tell me, if you don't tell me who it is, I'm going to put you in contempt, because that is not attorney-client privilege. Attorney work product privilege. I am not. How did you get that information supposedly from my chambers? Did somebody tell you? You should have told me. You got 5 minutes. Well, I don't need it. I want to continue. This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas. Don't take my notes. No.
All of this was sparked by a questionable, illegal ex parte meeting held with the judge, prosecutors, witness Woody, and his attorney without informing the defense team. And this type of meeting in secret would ultimately violate all the rules of court. And instead of addressing that issue at hand, the judge was more focused and fixated on who was the source of that information. It was speculated that Kayla Bumpus, ex-stand-in attorney for Woody, was the mole, but that rumor has been dispelled by a courtroom insider. It was alleged that during this secret meeting, Woody stated he wanted to plead the fifth. When that was shut down by both the judge and prosecution, he then stated he would get on stand and say that he unalived Nut, and that he also stated that he would lie, and the prosecution team allegedly did not have a problem with him lying on the stand. Allegedly. With all of this being said, Woody then got on social media live after court and stated something to the effect, "I never knew a judge and the DA could pressure you to testify." Needless to say, the waters continue to muddy in this trial. Several motions have been put forth throughout this trial, from requests for mistrials and judge recusals. It has been a hot mess. And as members of the in-house court audience share the ins and outs of proceedings and the ambience of the people inside the courtroom, it is clear that there is tension in the air, even amongst members within the prosecution team. It was alleged that a courtroom observer witnessed Prosecution Hilton crying, leaving the courtroom and talking with Prosecutor Love before returning back from break. It was also alleged that Woody, although a witness for the prosecution, requested to speak with the defense team. It was stated that he was not allowed his request and later returned to the witness stand. With Woody wanting to plead the fifth after receiving immunity and a perceived notion, whether true or not, of the prosecutors and Judge Glanville intimidating him to testify with threats of extended jail time, it makes you ponder about the behind-the-scenes events. Woody's testimony in comparison with a review of police interrogation videos paint a picture of an unreliable witness, which is why he may be facing impeachment. Now, impeachment of a witness. Impeachment of a witness, it refers to a process of discrediting or undermining the credibility of a witness during a trial by presenting evidence or asking questions that contradict their testimony or reveal a bias, inconsistency, or falsehood in their statements. And it is a common strategy used by attorneys to challenge the veracity of a witness and to cast doubt on the reliability of their testimony. And basically right now, the state's key witness is looking really unreliable. And remember, Woody was the first person to be picked up and indicted twice previously for the deceased, and the charges were dropped both times. It is not looking good in the long run for this trial, and it seems to be a never-ending money pit for Georgia's taxpayers. And in my opinion, continuing to move forward in this trial's current state would be a total waste of time and resources, because the way the cards are stacking up, it just looks like they're leaning towards a mistrial or an overturned verdict. And if I'm not mistaken, if this case ends in a mistrial, it's with prejudice, so Young Thug cannot be tried again, and that means defendants walk. This trial has been nothing short of interesting. So just stay tuned for more updates, because this trial is far from over. Don't forget to hit that like button, follow, subscribe for all the latest legal drama, and share this video with your fellow courtroom enthusiasts. And until next time, it's Rosie. I'm signing off. Stay rosy, my friends. But wait, real quick, one more thing before you go. Prosecution's witness, Woody, this is what he posted following court. Ja, I seen on your application you said you never went to jail. Me, correct. I never went to jail. I was taken.